Everyone. Christie Arkovich, you're a student loan attorney here in Tampa, Florida. We have been blogging about changes in student loan stimulus and student loan bills that are coming up, things that have already occurred. We've been blogging about that. We've been doing YouTube videos. We have this YouTube series up, all in the effort to try to help get this information out and practical advice as to how to apply it to end your student loan debt. And so today I'd like to focus on a blog that we just wrote. It's basically about some significant changes that are happening behind the scenes by the federal government and the Department of Education. And so while everyone was talking about cyberpunks and NFTs on Twitter this past weekend, as well as the impact of various amendments to the infrastructure bill and how they might affect cryptocurrencies, I know that was a huge topic, and development in that blockchain tech, there was significant movement on the student loan front. And so this was overlooked. When you turned on CNN or whatever, they were all talking about cryptocurrency, blockchain, impact on infrastructure bill, what's holding it up, what's being debated. And all along, we had the Biden administration. They announced this past Friday afternoon that they were extending the federal loan restart from October 1 to February 1 of 2022. So that means anyone who expected a loan payment to start becoming due again come September this year, they've gotten a little bit more reprieve until February 1 of 2022. And so an interesting question is, where might that money go for the next few months? And that may be where cryptocurrency and the stock market gets a little bit extra boost. Also on Friday, the Department of Education announced that it was creating a rulemaking committee to rewrite the regs for public service loan forgiveness, for the income contingent repayment plans, for borrower defense to repayment, closed school discharges, fault certification discharges, even interest capitalization, and then finally some technical legal things to arbitration, class action bans, and then even disability discharges. So what that means is they're rewriting the entire system. And so many of those systems, many of those programs, while they were good initially in their intentions, they virtually have been shut down or even misrepresented by various loan servicers in the past few years, to where even though someone might actually be eligible for a program, their servicers are not communicating their eligibility to the borrowers, and the message isn't getting across, as well as people don't know what to do. The system is very complicated, and having someone on your side to help you figure out what to do is sometimes the difference between success in writing off these loans and not success and still having them forever. So the Department of Education also announced that it was reversing its policy regarding preemption in state consumer laws. So what does that mean? That last one is quite a doozy, and it's a change to that student loan debt relief advocates like myself have been hoping for from this new administration. It's a giant step forward towards preventing unfair or deceptive practices by student loan servicers. And what this means is a practical matter. Several years ago, we worked with class counsel to file a couple class actions against large servicers for misrepresenting public service programs. Several of our clients were told by their servicers that they were in a program with actual target dates for discharge, when in fact they weren't even eligible for any public service loan forgiveness because they simply had the wrong type of federal loans. And it was astounding to me that servicers could get away with that. They knew what they were doing. It takes me less than 30 seconds to tell a client what they need to do to qualify for public service loan forgiveness, but yet servicers manage to screw this up massively. You may have read about this. In a lot of the newspapers, they publicized that 99.5% of borrowers who applied for public service loan discharge after 10 years were in fact denied. And the biggest reason for that was they simply had the wrong loan type. And so mistakes like this, whether intentional or accidental, they cost borrowers hundreds of thousands of dollars. They made them restart the 10-year clock that showed the hopelessness of the system as a whole. And we had a number of clients just like this, where they were told by their servicers, the only thing they could do is simply consolidate to a direct loan and restart that 10-year clock all over again. So one of our clients' cases, Lawson Ross v. Great Lakes Education Corp. In the 11th Circuit here in Florida, was actually cited by Ed in support of its decision to reverse this policy this past weekend. We haven't seen a dime for our efforts in this case, and maybe we never will. But I am proud of our clients, our firm, our colleagues at Schrader Law, at Kynes, Markman, and Fellman, and most of all, the Student Loan Defense Vice President and Chief Counsel, Dan Zeibel, for their time and efforts to hold servicers accountable for their conduct to prevent public service student loan forgiveness as promised to the most deserving of borrowers. So we would like to thank all of them. Going forward, student loan servicers for federal loans, once deemed safe from these pesky consumer laws, will be held accountable. Things like correcting misapplied payments, communication of wrong information, suggesting forbearance for no other reason than to get the borrowers off the phone quicker to save precious servicing time. All this misbehavior now has an expiration date. There is a 30-day comment period, but I don't expect much to damper the enthusiasm for the new administration to end the egregious misdeeds committed by federal student loan servicers in the name of simply saving a buck. I've long been a believer of our student loan system, actually having worked for the other side back in the mid-1990s to early 2000s, but I recognize that that system has been hijacked for quite some time, and it really needs a complete overhaul. This overhaul is happening now, and that's the message that the Department of Ed is communicating by its rulemaking committee that it is establishing to address each one of these programs. And so I'd like for you to stay tuned, keep watching our blog, subscribe to our YouTube channel, keep apprised of the new stimulus as it becomes announced. Now, our videos and our blogs are intended to, first of all, be titled for the type of relief that's being offered. I think that's important. You don't have time to sit through 2-hour videos to try to figure out what's going on. A lot of times reading about it on the internet and through news articles, it doesn't tell you what you need to know. So we try to, as a practical matter, say, here's what the stimulus is, here's what it will help, and here's who should be looking for this, and here's what you need to do. Is it automatic? Do you have to do anything at all? Or is it something that you actually need to file something for or ask for or something like that? So please subscribe. This will help me, and in turn, it will help you. And also, if you have student loans and you'd like to set a one-on-one consultation with us, please go ahead and reach out. We simply have an email, info@christiearkovich.com, or office number on our website. We can go ahead and set that one-on-one consultation. So I hope you all have a great day, and keep your fingers crossed for if you have student loans, hopefully something coming up. If we don't already have it, it will help you in the near future. All right, thanks.